California's Assembly Bill 5, or AB5, presumes that all workers in California are employees unless an employer can show otherwise through what is called the ABC test, which consists of 3 prongs. In order for a worker to prove that they're an independent contractor, they must show A, that they're free from the employer's control and direction, both in the contract and in fact. B, that they're performing work that is outside the usual course of the hiring entity's business, and C, that they're customarily engaged in an independently established trade, occupation, profession, or business. The B prong of the test appears to make it nearly impossible for a leased-on owner-operator to be considered an independent contractor, leading many in the industry to say that AB5 could force the end of the owner-operator model in California. The state passed AB5 into law in 2019, but a preliminary injunction in 2020 prevented it from affecting the trucking industry due to a lawsuit by the California Trucking Association, which argued that AB5 was preempted by a federal law known as F4A. California's Attorney General then asked for the Ninth Circuit to review the injunction. In 2021, the Ninth Circuit ruled 2-1 that AB5 is a generally applicable labor law and called for the removal of the preliminary injunction. In response, the California Trucking Association filed a petition to the U.S. Supreme Court, to which OOIDA supported through an amicus brief. On June 30th, 2022, the Supreme Court denied that petition. So where is AB5 today? Well, it's hard to say. California hasn't provided any guidance regarding how they'll enforce the law, though OOIDA has reached out to the governor's office for clarification and is still unclear how the courts will interpret the law. For example, the preliminary injunction focused solely on the F4A argument. The district court did not, however, speak to the California Trucking Association's second argument, which was that AB5 violates the Commerce Clause of the U.S. Constitution. The Commerce Clause prevents states from passing legislation that discriminates against or excessively burdens interstate commerce. The California Trucking Association argues that AB5 creates unnecessary burdens for motor carriers. For example, motor carriers would no longer be able to use an independent contractor for the entire duration of a freight movement if the load originated in other states and ended in California. Instead, the carrier would have to terminate that movement at the border and arrange for the final leg to be completed by an employee driver. Likewise, carriers couldn't use an independent contractor to complete the first leg of the trip if the load originated in California and ended in a different state. Again, they would need to arrange for an employee driver to complete the first leg. So what's next? Right now, we're in a wait-and-see mode. The California Trucking Association is already lobbying the state legislature to reverse AB5, and there still may be legal opportunities for OOIDA and others to pursue. So until then, stay tuned.